Law is order. This agreement shall be binding upon the parties and their respective successors, assigns, heirs, executors, and administrators. In the event of any dispute arising out of or related to this agreement, the parties agree to submit the dispute to mediation before resorting to litigation. The mediation shall be conducted in accordance with the then current rules of the American Arbitration Association. The parties agree to share the costs of mediation equally. If the dispute is not resolved in mediation, the parties agree to submit the dispute to binding arbitration in accordance with the then current rules of the American Arbitration Association. The arbitration shall be conducted in state, and the decision of the arbitrator shall be final and binding on the parties. The parties agree to share the costs of arbitration equally. In the event either party breaches any of the terms of this agreement, the non-breaching party shall be entitled to seek injunctive relief and any other available legal remedies. This agreement shall be governed and construed in accordance with the laws of the state. The parties agree that the substantive laws of state shall apply without regard to the choice of law provisions of such laws. The parties agree that any legal action related to this agreement shall be brought in the courts of state, and hereby consent to the jurisdiction of those courts. In witness whereof, the parties have executed this agreement as of the date first written above. Section 1 Vesting Clause. This agreement shall vest beginning on the effective date and shall continue in full force and effect until terminated in accordance with the terms and conditions of this agreement. Section 2 Termination. This agreement may be terminated by either party at any time upon written notice to the other party, provided that any outstanding obligations or liabilities of either party under this agreement shall remain in effect. In the event of termination, each party shall immediately cease all activities related to this agreement. Article 3, Section 1. Overview of the Judicial Vesting Clause. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The Judicial Vesting Clause is a clause in the United States Constitution that vests the judicial power of the United States in the Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. This clause grants Congress the power to create the lower federal courts and to determine the jurisdiction of these courts. In addition, the Supreme Court can review the decisions of the lower courts. This clause is important because it is the basis for the federal court system and allows Congress to create and modify the court system as necessary. This clause also ensures that the Supreme Court remains the highest court in the land and can review the decisions of the lower courts. Article 3, Section 1. Inherent powers over judicial procedure. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Inherent powers over judicial procedure. The Supreme Court and the inferior courts established by Congress have the inherent power to determine the rules and procedures of the court. This includes determining the form and manner of pleadings, the form of the process, the rules of evidence, the rules of discovery, the rules of civil and criminal procedure, and other matters pertaining to the administration of justice. The Supreme Court has the ultimate power to review decisions of the lower courts and to set binding precedent for all courts. The court also has the power to issue writs of certiorari, mandamus, and other extraordinary writs. Furthermore, the courts may grant injunctions, issue declaratory judgments, and issue other orders necessary to the orderly administration of justice. Article 3, Section 1-2, Historical background of judicial review. The U.S. Constitution establishes the Supreme Court of the United States as the ultimate arbiter of the law. Empowered to resolve conflicts between states, interpret laws passed by Congress, and review executive actions. The power of judicial review, which allows the Supreme Court to declare laws and executive actions unconstitutional, has been a cornerstone of American democracy since Marbury v. Madison, 1803. In that case, Chief Justice John Marshall declared that the Supreme Court is the final authority in interpreting the U.S. Constitution, and that it could strike down laws that violated its provisions. Since then, the Supreme Court has used its power of judicial review to shape American law and society. In the 19th century, the court struck down laws that restricted the rights of African Americans, such as the infamous Dred Scott decision of 1857. In the 20th century, the court declared segregation in public schools unconstitutional in Brown v. Board of Education, 1954, and established the right to privacy in Griswold v. Connecticut, 1965. In the 21st century, the court has continued to shape the law, most notably in the landmark ruling of Obergefell v. Hodges, 2015, which established the right to same-sex marriage. The power of judicial review has been a source of controversy since its inception. Critics argue that the Supreme Court should not have the power to overturn laws passed by Congress, and that its rulings often reflect judicial activism rather than a strict interpretation of the Constitution. Supporters of judicial review argue that it is necessary to protect the rights of minority groups and ensure that the government acts in accordance with the rule of law. While the debate over judicial review is unlikely to be resolved anytime soon, it remains an important part of American democracy. Inherent powers of federal courts. The inherent powers of federal courts are powers that are not specifically granted by the Constitution, laws of Congress, or rules of procedure, but rather are powers that are assumed to exist to ensure that the court is able to fulfill its duties. These inherent powers include the power to sanction individuals or organizations for contempt of court, to control their own docket, to issue orders to protect its process and to enforce the court's judgments. The Supreme Court has also held that federal courts have inherent power to dismiss an action based on lack of jurisdiction, to transfer a case to another court, and to stay proceedings. Art. III. S. 1.3 Marbury v. Madison and Judicial Review. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. Marbury v. Madison and Judicial Review. In the landmark case of Marbury v. Madison, 1803, the Supreme Court established the power of judicial review. This power gives the court the authority to evaluate the constitutionality of laws and executive actions. This means that the Supreme Court can decide whether laws passed by Congress or actions taken by the President violate the Constitution. This power is an integral part of the Supreme Court's role in the judicial branch of the United States government. Art. III. S. 1.4.1 Overview of inherent powers of federal courts. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. Section 4. The Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions, and under such regulations as the Congress shall make. The inherent powers of the federal courts are those powers that are necessary for the courts to function properly, and they derive from the federal judiciary's constitutional and statutory authority. This includes powers such as the power to issue writs, the power to punish for contempt, the power to decide cases, the power to interpret the law, and the power to regulate court procedures and practices. Inherent powers are also those powers that are necessary for the courts to protect their own judgments, such as the power to enforce contempt orders or to compel parties to obey court orders. Delegated powers, which are those that Congress explicitly grants to the federal courts, are distinct from inherent powers. The Supreme Court has held that the federal courts have the power to make necessary ancillary orders, to ensure that their judgments are respected and enforced. This includes the power to issue writs of execution and to appoint receivers, as well as the power to punish people for contempt of court. Inherent powers are also distinct from the inherent powers of the states. States have their own inherent powers, which derive from their own constitutions and laws. These powers can include the power to issue writs and orders, the power to punish for contempt, and the power to regulate court procedures and practices. However, the U.S. Constitution and federal law place restrictions on the state's ability to exercise these powers. In summary, the inherent powers of the federal courts are those powers that are necessary for the courts to function properly, and to protect their own judgments. These powers derive from the federal judiciary's constitutional and statutory authority, and are distinct from the delegated powers granted to the federal courts by Congress as well as from the inherent powers of the states. Art. III. S. 1.4.3 Inherent powers over contempt and sanctions. Article 3, Section 1-4. 3. The Supreme Court shall have the power to impose sanctions, including contempt, upon any person or entity engaging in or aiding in any act of contempt or disobedience of its orders or decrees. The court may also award damages, costs, and other remedies as it deems appropriate. The court shall be responsible for enforcing its orders and decrees, and any sanction imposed by it shall be binding on all parties to the action. Art. III. S. 1.4.4 Inherent power to issue judgments. Article 3, Section 1. The Supreme Court shall have the power to issue judgments in all cases brought before it and to exercise original jurisdiction in all matters arising under the laws of the United States. Article 3, Section 4. The Supreme Court shall have the inherent power to issue judgments in all cases brought before it. Such judgments shall be based on the facts and law and shall be binding on all parties to the suit. The Supreme Court shall have the power to modify, vacate, or enforce its own judgments and to issue such orders as are necessary to ensure justice is done. Congressional control over judicial power. Congress has a limited role in controlling judicial power. Congress has the power to set the size and scope of the federal judiciary as well as the number of justices on the Supreme Court. Congress also has the power to impeach and remove judges from office and can pass legislation to overturn or modify court decisions. Finally, Congress can pass legislation that limits the power of the courts, such as limiting their jurisdiction or their ability to hear certain types of cases. Art. III. S. 1.5.1 Overview of Congressional Control over Judicial Power. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. This section of the Constitution gives Congress the power to create and establish federal courts. Congress has the authority to set the number of justices that serve on the Supreme Court and to create other federal courts such as the Court of Appeals, district courts, and special courts. Congress also has the power to determine the jurisdiction of these courts, meaning what types of cases they can hear. Congress also has the power to set the number of judges that serve on each court, the geographic boundaries of each court, and the qualifications of judges. Additionally, Congress has the power to set the salaries of judges, to impeach and remove judges, and to modify the rules of procedure for the courts. Congress also has the power to set the budget for the courts, which determines the staffing and resources available to the courts. Overall, Congress has a great deal of control over the judicial power of the United States. This control ensures that the judiciary is structured in a way that best serves the needs of the country. Congress's ability to shape the judiciary helps the courts remain independent and impartial when deciding cases. Art. III. S. 1.5.2 Reopening Final Judicial Decisions. Article 3, Section 1 to 5.2. Final judicial decisions shall only be reopened in exceptional circumstances and upon approval of the court. The court may, in its discretion, consider requests to reopen a final judicial decision when there is a showing of newly discovered evidence, fraud or mistake, or a manifest injustice that would result from not reopening the decision. The court may also reopen a final judicial decision whenever there is an overriding public interest in doing so. The court shall consider all relevant factors in determining whether to reopen a final judicial decision. Art. III. S. 1.5.3 Imposing non-adjudicatory functions on courts. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The Congress may, to facilitate the administration of justice, impose non-adjudicatory functions on the courts, such as the authority to provide administrative services, issue procedural rules, and conduct research in matters of law. Such functions must, however, be consistent with the judicial power and the role of the courts as independent and impartial tribunals. Thanks for watching.